Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, Law Street Media, and Fastcase. I'm your host, Tom Hagee. Let's say you're buying a bicycle, and let's face it, you could use the exercise. And what's more fun than a bike? You're not the only one who needs that exercise either. That wheezing sound coming up on your left is probably, well, it's someone like me. But that's not why we're here. How much you paid for that bike is why we're here. Here's a fictitious, I was going to say probably improbable scenario, but I just heard of one way more complicated today. So here's a fictitious and yet realistic scenario. Let's say you buy your bike at a local bike shop. You don't, you don't buy it online like a slacker. And the frame, I buy socks online. All right, this isn't about me. The frame of the bike you bought at your local shop, let's say it was built in Taiwan. Then it was shipped to Germany where they assemble it. And there the German company added a bunch of things, and including tires. It purchased the tires from a company made in Italy. They're really known for their tires. The Italian tire maker purchased the rubber for those tires from Thailand. And along the way, everyone is paying for, shipping, storage, and who knows what else. And that's a simple supply chain. They're not so much chains as they are webs, supply webs. That's not going to catch on. When somebody in that chain is a baddie and they conspire with others in their own supply chains or with competitors to fix prices, that reverberates through the chain. Each link in the chain is buying directly from someone who bought directly from someone else. Beyond that direct buyer, those are indirect buyers, and they're kind of like first, second, and third cousins, not nearly as much fun. You might think that if you purchase a product for a price inflated by these baddies in the supply chain, you would be able to collect damages. Unfortunately, you would be wrong some of the time. Not everyone harmed by price fixing is able to collect, and it has nothing to do with whether they deserve it. Some states don't have antitrust laws that give them standing. I was shocked. And now so can you. While these states provide protection for direct or first purchasers, the gap remains for those who purchase products whose prices were fixed up in the chain. But, you might say, indirect purchasers have standing under federal law, and states have their own statutes modeled on federal law. And you would be correct. So what's the deal? Has the Supreme Court chimed in on this issue? If federal law protects indirect purchasers, why do citizens of some states have standing and others do not? I think I already answered the question, but let's go on anyway. Are any changes in the wings that could impact antitrust litigation and the rights of consumers and businesses from state to state? These are excellent questions. I know because I wrote them down. For answers to these questions and more, because there's always more, listen to my interview with attorney Austin Cohen of Levin, Sedran, and Berman of Philadelphia. Austin's practice includes, as you would suspect, antitrust and business law, but he also practices in class actions, torts and product liability, and environmental damage litigation. Austin received a BA in economics and history from the University of Pennsylvania. Go Quakers! And a JD cum laude from the University of Pittsburgh School of Law. Go Panthers! And with that, here is my interview with Austin Cohen of Levin, Sedran, and Berman of Philadelphia. I hope you enjoy it. Austin Cohen, thank you very much for speaking with me today.
Thank you for having me.
So in the lead up to this, the message I've gotten from you is that not everyone harmed by price fixing is able to collect. Has nothing to do with whether they deserve it. Consumers and businesses, indirect purchasers of products whose prices are fixed up in the supply and distribution chain may not collect damages in a group of states that, somewhat surprisingly, do not have antitrust laws that give them standing. So is that accurate? And is that an accurate description of what we're going to talk about today?
That is an accurate description. It's sort of the idea that there's a whole category of people who would be injured by antitrust or anti-competitive conduct. They can't get compensation in the federal courts, and they can't get compensation in many of the states. And And they would be the category, as you mentioned, of indirect purchasers, people in the supply chain that purchase a product, pay an overcharge, but they don't purchase from the violator. They don't purchase from the party that actually engaged in the price fixing.
Yeah. Okay. Let's spell that out for folks. So the direct purchaser, indirect purchasers. So clarify that for people who aren't familiar.
Probably it makes sense to start with sort of the scheme of the federal antitrust law,
okay,
which is, you have the Sherman Act, which makes two categories of conduct illegal. First would be Section 1, which would be any agreement to restrain trade. And that's when you think of your classic price fixing. Two competitors get together and say, why don't we both raise our prices 10%? That's a cartel to fix prices between competitors. It could be to allocate customers, allocate markets geographically. There are lots of different ways you can enter into a cartel agreement. The second one, Section 2, 15 U.S.C. Section 2, is an attempt by one or more party to monopolize a market. It can be a single actor who's trying to monopolize a particular market, or it can be an agreement among multiple actors to monopolize markets. So that defines what's illegal under the federal law. The next step is who has a right to sue. And that falls under the Clayton Act, which is 15 U.S.C. Section 15, which gives a private right of action to individuals. As a matter of fact, it goes beyond giving a private right of action. It actually says any person who shall be injured in his business or property by reason of anything forbidden in the antitrust laws may sue therefore. And it says that the private party suing can recover threefold damages plus costs of suit, including reasonable attorney's fees. So that's the federal scheme that's been around for about 100 years.
Okay.
Many states have copied that sort of layout or those laws and have complementary antitrust laws under state law. Now, that's the standing under the federal law, which says any person, but then the Supreme Court over the last 100 years has come along and refined that. Initially they said, well, it can't be any person. It can only be people who have suffered some sort of injury we don't want to allow, because you can't allow every single harm to result in a lawsuit. And that goes back mid-century, the 50s, 60s, I think. But then the ones that I think we're going to focus on begin in 1968, when the Supreme Court decided Hanover Shoe.
Okay, let's talk about that one. Just back to
Sure.
so the key statutes are Sherman Act and Clayton Act, and typically what happens is states have mirrored them, some have not, and you're going to tell us more about which is which. Just to clarify too, I mean people who are attorneys listening to this will know this, but one thing I've learned in looking at this is that a lot of people, I think, assume that a monopoly is automatically illegal. And,
well, not always.
And that's not the case. Yeah.
That's not the case. For instance, we have a lot of things called regulated monopolies in the country where you couldn't have competitors. And that, for instance, is what happens with utilities, water, electric. You wouldn't want to have 10 different companies putting up poles and putting power lines through your neighborhood. So you have one company, but then to prevent them from charging monopoly prices, which is when you're the sole seller, you can usually charge a higher price. States will regulate them, or the federal government will regulate them in some way to require them to file requests to raise prices and things like that. So there are instances where you have to have a monopoly simply because you can't have multiple providers of a service.
Right.
But it's also illegal when you have one of the cases I'm working on is what's called predatory pricing, where let's say you have 10 companies competing in a market, and one of those companies decides that they want to drive their competitors out of business. So if it costs $1 to make the product, they decide, you know what, let's sell that product for 50 cents. And we're going to sell it for 50 cents, even though we're going to lose money, until we drive all of our competitors bankrupt. And then once they are bankrupt, we can buy their assets, maybe their factories will be dismantled, but at that point, we will have a monopoly. and then we can raise the price to $5. And the amount of money we make charging $5 will be more than enough to offset the losses we had when we were selling for 50 cents during the what's called the predation period.
Okay.
So that's an illegal way to obtain a monopoly.
Okay. All right. Kind of throwing your heft around to crush others. So, okay. So I interrupted you. You were going to talk about the Supreme Court ruling, Hanover Shoe.
In Hanover Shoe, before Hanover Shoe, you could have, let's say, take a classic cartel example of sugar. Sugar manufacturers get together, they agree to raise the price of sugar up 10 cents a pound. And they sell that sugar to a candy manufacturer who takes the sugar and incorporates it into candy. And then that candy manufacturer sells the sugar, the candy bar, to a wholesaler who sells it to a retailer who sells it to you who goes into your local store and buys a candy bar. Before Hanover Shoe, anyone technically could sue, both the candy manufacturer who purchased directly from the sugar company, as well as the wholesaler, the retailer, and the end consumer. And what often happened was when, say, the candy manufacturers sued, the sugar companies could say, well, you're only entitled to recover the amount of damages that you paid and weren't able to pass on. So if you paid an extra 10 cents a pound, but you were able to charge 9 cents more for a pound of candy, then you only had 1 cent's worth of damage. It's called the pass-on defense. So in 1968 in Hanover Shoe, the Supreme Court said, we really want to emphasize the deterrent effect of the antitrust laws. So what we're going to do is we're going to say that a defendant cannot raise pass-on as a defense, even if the purchaser was able to pass on the entire overcharge. They can still sue and recover the full 10 cents. So that became the law in 1968 with Hanover Shoe. The next big step was in 1977, as the counterpart was Illinois Brick, which was where the Supreme Court said, well, if we're not going to allow pass on as a defense, then it seems like we shouldn't be allowing the second, third, and fourth tier purchasers, the indirect purchasers, to also have a claim. So in Illinois Brick, they said under the federal antitrust laws, or under the antitrust laws, only the direct purchaser can bring suit, but that direct purchaser can recover the entire overcharge, regardless of whether or not they were able to recover the overcharge by passing it on down the distribution chain. And really it comes down to the idea of deterrence versus compensation. The Supreme Court has squarely come down on the side of deterrence. It recognizes there is a compensation element to this, but the purpose is deterrence. And Posner and Landis, in an article discussing antitrust law and indirect purchasers, or whether or not how the antitrust laws have worked, have said that the primary emphasis of the law should be on deterrence, not compensation. Because if you deter an antitrust actor from entering into an illegal agreement, you don't have to compensate anyone. There's no agreement. So the result is you want to deter, so you want to give a maximum incentive to the direct purchaser to bring a suit, which means no pass on, the treble damages, et cetera. And the effect, though, is that you're not providing compensation to those indirect purchasers down the chain.
How have states adapted to this? And you also mentioned an Illinois Brick repealer. So how have states adapted?
Right. So the first thing that happened was many states that had antitrust laws that were similar to or modeled after the federal statutes, their courts then interpreted those statutes as having the same restriction. So you had a lot of states that came along and said, well, if we want to encourage deterrence, we're going to follow the federal court model, and we're going to hold that indirect purchasers can't bring a suit. As a result of that, many states passed what have been come to be known as Illinois Brick repealers, which are laws that allow for indirect purchasers in the states to get compensation. And there are lots of different ways you could structure that, lots of different rules you can use to provide compensation, because you also have to have a system that's manageable. You know, one problem is if you have everybody suing, it becomes very difficult in terms of economics to show how much of the overcharge was absorbed at that tier and how much was passed on. Like we said, with the wholesaler, the manufacturer to the wholesaler to the retailer to the consumer, you have 4 layers there. You can have a lot more technically. Each one of those tiers would be trying to prove that they paid the entire overcharge and they weren't able to pass it on. Some states have limited how many tiers of indirect purchasers can sue. Some states have held that pass on may not be a defense, or they've actually set, say, a statutory cap on the amount that you can recover. So there are lots of different rules about how indirect purchaser statutes work that vary among the states.
Something you said, how many layers of indirect purchasers? So
with the sugar example that I was using, let's say I put sugar into a candy bar, and the amount of sugar I use for that candy bar represents a 10-cent overcharge. I should have paid 10 cents for the sugar. I paid 20 for the candy bar. So I've got 10 cents of damages. When I sell the candy bar to my wholesaler, I can raise the price, but I can only raise it by 8 cents, because if I go too high, they're not going to buy the candy bar. So now I've passed on 8 cents of my overcharge, and I still suffered 2 cents worth of damage. Then the wholesaler, he resells that candy bar to the retailer, and he can pass on, say, 5 cents. So he's paid 3 cents worth of damages. And technically, if you went down the chain, the total overcharge would add up to 10 cents. But it might be a couple of cents with the direct purchaser, and then the first tier indirect, and the second tier indirect, and the third tier indirect.
Okay.
And the ultimate consumer.
How did some states never adopt this approach?
Over the intervening, 40 odd years, many states have enacted Illinois brick repealers. By my count, approximately 32 states, plus the District of Columbia, have enacted laws that allow for indirect purchasers to be compensated. Now, some of them only allow for purchasers within the state. Some of them are only for the first tier, but at least there's some degree of compensation. And in addition to the consumers being compensated, many states have allowed for the attorney generals in those states to either sue on behalf of the state to the extent the state there suffers harm by purchasing products at a price fixed, or even to sue on behalf of the consumers under a parens patriae action. Now, if 32 states have those laws, that means 18 states have not yet enacted laws that allow for indirect purchasers to bring suit. Or I should say, either a law or the courts in those states may have interpreted their antitrust laws as still allowing for indirect purchasers. So it's a right. You could say an Illinois brick repealer, or you could say precedent that allows for indirect purchasers to bring suit.
So what are the consequences for citizens in these states?
Well, the consequences, for example, I'm in work in Pennsylvania. Pennsylvania doesn't have an antitrust statute, and Pennsylvania obviously then doesn't have an indirect purchaser statute. So the consequences are that if you suffer antitrust injury in Pennsylvania, your only remedy is to bring a federal suit claim. And if you can try to bring it under the Unfair Trade Practices Act, you can try and bring it under the consumer law, but there's no antitrust law that gives you standing to bring a claim. And the result would be that you can't recover under state law. And if you're an indirect purchaser, it means you have no right to recover under the antitrust laws because there is no indirect purchaser law. I'll give you an example, a couple of examples recently. There was an $81 million settlement in price fixing claim against manufacturers of capacitors. I was involved actually in the direct purchaser class action that was out in California. But in addition to that direct purchaser action, there was an indirect purchaser action brought on behalf of residents and consumers in 30-odd states where they have indirect purchaser laws. So that $81 million settlement will be distributed among claimants in the states where they are allowed to bring indirect purchaser claims. So whereas, for instance, California residents will get millions of dollars back for money that they overpaid for products that include capacitors, Pennsylvania residents will get zero back. Sort of a little bit of background, capacitors are a component that are in every electrical circuit. They range in size from a grain of rice to the size of a trash can. to give you sort of some context, your cell phone has about 600 capacitors in it. There are tens of thousands of capacitors in your home between TVs, computers, appliances, phones, etc. And the claim was, for a period of time, Japanese capacitors manufacturers were charging super competitive prices.
You said supra competitive, so
super competitive is supra, S-U-P-R-A is
yeah, right.
a phrase we use. It just means a price that's above what the competitive price would be if the market was competitive.
Okay. In case anybody not familiar with it, it's not super competitive. I guess that would be different. Supra. Okay, as a Pennsylvania resident, I'm a little miffed. I've got all these capacitors. I know I probably have thousands. What's with Pennsylvania? Why is it now doesn't have that, and what change might be in play that you're aware of or you're working on?
Well, Pennsylvania, along with the other states, it's tough to put a finger on why they haven't enacted it yet. And it's not just the consumers. Like I said, that the statutes can also give a right or standing to the attorney general for the state to bring an action on behalf of the state. So, for instance, you can think of the millions of dollars Pennsylvania has spent buying equipment that has capacitors out of state funds that they can't recover for. If there was an indirect purchaser statute in Pennsylvania, then and it included a right for the attorney general to bring a claim, the attorney general could bring a claim. The consumers could bring a claim, or at least maybe be part of these lawsuits, because they would be defined as part of the class. It would include Pennsylvania consumers. So what is going on is there are groups that are trying to convince states on behalf of consumers to enact indirect purchaser statutes, or there are groups that are seeking to have states enact indirect purchaser statutes on behalf of consumers and on behalf of the state attorneys general as well. I'm involved with one group that's prepared papers explaining how antitrust laws work, and explaining the benefits, both for purposes of deterrence and compensation, to allowing for indirect purchasers to also bring a claim.
Okay. I'm just curious, it seems like kind of a no-brainer that, a state would want this to protect businesses and the state and citizens. So is there opposition to this?
I'd say the opposition will oftentimes come from business interest groups, companies that are afraid that they will be subject to increasing levels of liability if they're found guilty or liable for participating in a anti-competitive scheme. Some of the indirect purchaser statutes that are out there will have an offset, or will, like we were talking before about the pass-on, they'll allow for pass-on as a defense, saying that, well, if they paid X to the direct purchasers, they shouldn't have to pay again to the indirect purchasers. Now, technically, the law already says to maximize deterrence, we're going to allow for more than just estimated single damages. That's why there's a treble damages right in the Clayton Act. But on top of that, there really isn't or shouldn't be a problem with separate federal and state liability. Just as recently as 2019, the Supreme Court reaffirmed the concept of dual sovereignty, saying that liability under federal law is separate for liability under the state law for the same conduct. And that was Judge Alito, actually, who even wrote that. So it upholds the idea that you can have indirect purchaser laws that punish the same conduct as the Sherman Act punishes, even to the extent that it could result in a company paying damages in federal and then again in state court.
Yeah, I guess I'm just a little baffled as to why. Because companies themselves want to be protected from price fixing. So it's just odd to me. Is there a certain type of company that's opposing this?
Well, yeah, I'm not really sure.
Okay,
I view this from the other side, which is I agree with you. I don't know why anyone would oppose it. Like I said, I was involved in the direct purchaser capacitors class action. And my client was a small company that manufactured components for solar panels. And they purchased capacitors that were price fixed. And they're a company. And the reason he wanted to be part of this litigation was when he found out that they had been price fixing, he was upset. He says, I try to deal fairly with my customers, and I assume my suppliers deal fairly with me. And it upsets me to learn that they weren't playing by the same rules.
Mm-hmm.
So in one sense, I think you're exactly right. Companies should want robust antitrust laws because they protect them from their own suppliers.
Mm-hmm.
But you have companies and trade groups that are just afraid that it could result in runaway liability, I guess.
Okay. Just in my experience, albeit limited, I just don't feel like anybody's ever seen like just giant awards that everybody said, oh, that's just outrageous. I don't know. But, not like in personal injury, people can argue about whether somebody deserved something or not. But I don't know. It just seemed like antitrust. I've just never heard of anyone running away. What is it? What do they call them? Nuclear verdicts in personal injury?
So one thing which we haven't really touched on is the way these cases are brought, which is, historically it was one large company suing another large company.
Mm-hmm.
Expensive. And it wasn't until I think the 60s when lawyers started to combine the concept of class action with the concept of antitrust.
Right. Okay.
So that's why you have antitrust class actions. They're really sort of two tools put together. And that's where you get attorneys like me who work on behalf of classes. Like I said, my client in the capacitors case was relatively small. They couldn't have afforded the millions of dollars to pay for experts and depositions around the country and around the world. But as a class action, you can, because it aggregates the harm. But the result is that's why you can get $600 million worth of settlements.
Mm-hmm.
Because you're doing it on behalf of hundreds of millions or billions of dollars worth of commerce.
Gotcha. Yeah, antitrust settlements are the ones I've seen reported. They are in that range. They are giant. Is there anything else you wanted to add about either what's going on in Pennsylvania or anything else in general?
Well, so in Pennsylvania, like I said, there are efforts in Pennsylvania and other places to try and have states enact Illinois brick repealers and give residents of those states the right to be compensated for injury they suffered. I know last term there was a bill introduced in the Pennsylvania legislature that would have provided for an antitrust statute for Pennsylvania as well as an Illinois brick repealer statute. I don't think it went forward, but I know that we're working on having a similar bill come up again. I think it really shouldn't be a political issue. It's more of just it's actually, I wouldn't even say consumer rights. Like you said, it's a corporate and consumer rights issue.
Yeah. Saying it shouldn't be political. I think so many sentences start that way these days. Austin Cohen, thank you very much for talking with me about this today. I really appreciate it.
I appreciate the opportunity to spend the time with you and hopefully to help educate your audience about antitrust law and about their rights to recover for overcharges they may have paid.
That concludes this episode of the Emerging Litigation Podcast. If you have any questions about anything you heard on the podcast or would like to participate, please write to me at editor@litigationconferences.com. The Emerging Litigation Podcast is a co-production of HB Litigation and Critical Legal Content, my companies, and Fastcase, and our friends at Law Street Media, David Nair, Editor-in-Chief. This is also the audio companion to the Journal on Emerging Issues in Litigation published by Fastcase, Full Court Press, Tom Hagee, Editor-in-Chief, Morgan Wright, Publisher. I'm your host, Tom Hagee. That's why I'm talking, and I don't know if it needs to be said, but this is not legal advice. Unless telling you it's not legal advice is legal advice, although I'd argue it's just plain common sense. Thanks for listening. Give us a rating, share with friends. See you on the next episode.